Question 556. The seller's warranty in a listing agreement should include all of the following guarantees, except A. The seller's right to sell the property according to the agreement terms, B. The seller not being obligated to pay a commission, C. The property not coming with any undisclosed liens against it, D. The seller's description of the property being accurate. Correct answer is B. The seller not being obligated to pay a commission. The listing agreement is precisely the document that establishes the seller's obligation to pay a commission to the real estate agent upon the successful fulfillment of the agreement terms, e.g., finding a ready, willing, and able buyer. A seller's warranty would never state they are not obligated to pay the commission, as that's the core of the agent's compensation. The other options are standard and necessary seller warranties in a listing agreement. A. The seller's right to sell the property according to the agreement terms. This assures the agent that the seller has the legal authority to convey the property. C. The property not coming with any undisclosed liens against it. This protects the buyer, and indirectly the agent, from title issues that could impede the sale. D. The seller's description of the property being accurate. This helps the agent market the property truthfully and avoids potential misrepresentation claims. Question 557. The following is real property, except A. A deed to a house, B. An grove of trees, C. A gold mine, D. A swimming pool. Correct answer is A. A deed to a house. Real property refers to the land and anything permanently attached to it. This includes things like buildings, trees growing naturally on the land, and mineral rights beneath the surface. A deed to a house is a legal document that represents ownership of the real property, the house and the land it sits on. The deed itself is personal property, a piece of paper that signifies the right to the real property. Question 558. Which statement is correct regarding promissory notes? A. Discounting a note refers to it being sold for more than the face value, or the amount still owed on the principal. B. They are the evidence of the debt. C. They are used as security for trust deeds. D. They are always used when real estate is sold. Correct answer is B. They are the evidence of the debt. Discounting a note means selling it for less than its face value or the outstanding principal balance. The discount represents the compensation to the buyer for taking on the note before its maturity. Selling for more than face value would be considered selling at a premium. Promissory notes are the evidence of the debt that is secured by a trust deed, or a mortgage. The trust deed, or mortgage, is the security instrument that pledges the real property as collateral for the loan evidenced by the promissory note. The note itself is not the security. While promissory notes are very common when real estate is financed with a loan, they are not always used. If a buyer pays the full purchase price in cash, there is no debt and therefore no need for a promissory note. A promissory note is a written promise by a borrower to repay a specific sum of money to a lender. It's usually with interest, according to a defined schedule. It serves as the primary legal documentation of the loan obligation. Note if the word always appears in an answer option. One exception prevents it from being accurate. Question 559. In California, the homestead law provides protection against A. Mortgage payment liens, B. Judgment liens, C. Mechanics liens, D. Liens based on child support obligations. Correct answer is B. Judgment liens. A homestead refers to an owner-occupied property. In this state, the homestead law only protects against judgment liens. The protection can be attained by filing a homestead declaration with the county recorder or by claiming the exemption after a judgment lien-based foreclosure on the homestead property has been filed. The primary purpose of the homestead exemption in California is to protect a certain amount of equity in a homeowner's principal residence from being seized and sold to satisfy judgment liens obtained by general creditors, e.g., from lawsuits, credit card debt, etc. The homestead law offers this protection to ensure that individuals and families have a place to live, even if they have outstanding debts. The protected amount varies depending on the county and is tied to the median home sale price, with a minimum and maximum limit set by law. It's important to note what the homestead law does not protect against. A. Mortgage payment liens, deeds of trust. The homestead exemption does not protect against foreclosure by a mortgage lender if the homeowner defaults on their mortgage payments because the homeowner voluntarily used the property as security for the loan. C. Mechanics liens. These liens are placed on a property by contractors or suppliers who have provided labor or materials for improvements and have not been paid. Homestead laws generally do not protect against these specific types of liens. D. Liens based on child support obligations. Judgments for child support, and often spousal support, are typically exempt from homestead protection, meaning a home can be sold to satisfy these debts. Question 560. A real estate investment trust, right, must invest at least of its total assets in real estate property and cash. A 0, 25, B 0, 5, C 0, 75, D 0, 99. Correct answer is C 0, 75. To qualify as a real estate investment trust, right, under U.S. law, a company must adhere to several requirements, including asset tests. One of these tests mandates that at least 75% of a REIT's total assets must be invested in real estate property, cash, and U.S. government securities. REITs must also be managed by a board of directors or trustees and distribute at least 90% of its taxable income to shareholders annually in the form of dividends. Question 561. If a salesperson resigns or is discharged by his broker, the broker must return the license certificate of the salesperson within A. 3 business days, B. 10 business days, C. 1 month, D. A calendar year. Correct answer is A. 3 business days. When a salesperson-broker relationship ends, regulations often require the broker to return the salesperson's license certificate to the issuing authority within a specific timeframe. 3 business days is a common timeframe mandated by many states. When a salesperson becomes employed by a broker, the commissioner must be notified within 5 days. Question 562. Once an option contract has been agreed upon, the following parties can decide whether to exercise the option. A. Optionee, B. Optioner, C. Both A and BD broker. Correct answer is A. Optionee. An option contract gives the optionee the exclusive right, but not the requirement, to purchase or lease a particular property. This right is valid for a specific period and at agreed-upon price and terms. The optionee alone holds the decision to proceed with the transaction within that time frame. They can choose to go through with the purchase or lease, or they can let the option expire. The optioner, the seller or lessor, is obligated to sell or lease if the optionee chooses to exercise their right. They do not have the choice to decide whether the option is exercised. Question 563. A deed would be void if A. Conveyed by a person in prison for robbery, B. Conveyed by a 17-year-old, C. Forged, in the possession of a purchaser for value, D. All of the above. Correct answer is C. Forged, in the possession of a purchaser for value. A person's imprisonment for a crime does not automatically render them legally incompetent to convey property. Unless they have been legally declared incompetent by a court, they generally retain the right to buy, sell, and own property. In most states, including California, a 17-year-old is considered a minor and lacks the legal capacity to enter into binding contracts, including the conveyance of real property. Such a deed is typically voidable by the minor. That's meaning the minor can choose to disaffirm the transfer, but it's not necessarily void from the outset. A forged deed is void, meaning it is invalid from its inception. It has no legal effect, even if it is subsequently transferred to a good faith purchaser who paid value for the property and had no knowledge of the forgery. The chain of title is broken at the point of the forgery. Therefore, a deed is void if it is forged, regardless of who subsequently possesses it or whether they paid value for it. The lack of genuine grantor consent in a forgery makes the deed legally non-existent. Question 564. A subordination clause in a trust deed usually benefits the most. A. The truster. B. The beneficiary. C. The trustee. D. All the parties benefit equally. Correct answer is A. The truster. The subordination clause makes it easier for the truster, borrower, to obtain a new loan on their property. By agreeing to allow a new lender to take a senior lien position, the existing lender enables the truster to access additional funds. This could be for various reasons beneficial to the truster, such as 1. Refinancing, obtaining a new first mortgage with better terms. 2. Home improvement loans, securing funds to increase the property's value. 3. Second mortgages or HELOCs, accessing equity for other needs. Although a new lender gains priority with a senior lien, the subordination clause is essentially an agreement by the original lender to take a lower lien position. This concession primarily benefits the truster, borrower, by enabling them to obtain additional financing against their property that would likely not be possible otherwise. The clause facilitates the truster's access to new loans. Without the subordination, the truster might not be able to get the new loan on terms that work for them. Question 565. If a real estate broker does not sign the purchase agreement in the appropriate place, then A. The seller does not have to pay the broker's commission. B. The broker will automatically have his license suspended. C. The agreement is voidable by either party. D. The agreement is still valid. Correct answer is D. The agreement is still valid. The primary purpose of the purchase agreement is to establish the terms of the sale between the buyer and the seller. The real estate broker's signature on the purchase agreement, while often included, is typically there to acknowledge their role in the transaction and to establish the agreement for their commission. The validity of the purchase agreement between the buyer and seller is generally not contingent on the broker's signature. The essential elements for a valid real estate contract are offer, acceptance, consideration, legal capacity of the parties, and a lawful purpose. The broker's signature is not one of these fundamental requirements for the contract to be binding between the buyer and seller. Such a failure to sign does not invalidate the purchase agreement or automatically result in the broker forfeiting his commission.